My first question to you, though, interestingly enough, is not on the Democratic critiques of you, although you can get to that. My first question is something that you might actually like the premise of the question, and that is Republican Senator Lamar Alexander has come out making news this morning saying he thinks the Democrats proved that Donald Trump did it, but there's no need for more evidence to prove something that has been proven, but that he views as, quote, not impeachable. Do you think that Senator Alexander was effectively adopting your argument?
I have no idea. I know that that's the argument I made. After I made it on the Senate floor, a number of senators came over to me and said that they had listened carefully to my argument and I had been quite convincing. And my argument is that the issue is not basically a factual one. It's whether the allegations in the two charges, abuse of power and obstruction of Congress, constitute impeachable offenses under the Constitution. I was brought in not to argue the facts, but only to make the constitutional argument that those two charges do not rise to the level of impeachable offenses. To the extent that Senator Alexander believes that I'm sure he arrived at that independently, not through my argument, but it is a parallel to the argument that I made, yes.
And that argument that you made also involved this claim that if the president believes that what he is doing for his reelection is in the public interest, then that itself is not impeachable. And so, given that this is still a live issue in the open trial,
I didn't make that argument.
Well, okay,
so let me be very clear.
Well, let me play for your reaction. Here's what you said on the Senate floor. Take a look.
If a president does something which he believes will help him get elected in the public interest, that cannot be the kind of quid pro quo that results in impeachment.
So my question to you would be then, if a president tries to get a rival arrested because he believes that that will make him unavailable to campaign and help his reelection, is that then unimpeachable because of his belief?
Of course it is. Of course it is. It's a crime to get somebody arrested improperly for the wrong reason. Let me make it clear. I began my argument by saying I supported the impeachment of Richard Nixon. Richard Nixon, whatever he did, he thought he did in the public interest, and he did it to get himself elected. Of course he was impeachable. The point I was making is that the president can't do anything illegal. He can't do anything that would be impeachable. But if he does something absolutely proper, and the purpose is a mixed purpose, part of it is to get himself elected, that the fact that he had a mixed motive can't turn innocent conduct into guilty conduct. I gave an example, which has not been quoted in the media. Abraham Lincoln
I would point out, I just have to point out, and then I'll let you finish, sir. You cannot complain about not being quoted in the media when you're getting time here for the purpose of quoting you. So please go ahead and tell us, but we can do it without the media criticism. I'm affording you the time.
Days of attack based on a false description of what I said. Abraham Lincoln sent the troops home to Indiana so that they could vote Republican. Obviously, he had mixed motives. He thought it was in the best interest of the country, but he also was trying to help his party. Another example I gave is that what if Barack Obama's decision not to bomb Syria after promising to do so was motivated in part by people telling him the left would be strongly objecting if he did that? You cannot psychoanalyze a president and try to parse what his motives are or what his motives are not. That's the only point I was making. I made it in response to the arguments made by the managers that even if a slight component of the president's decision to act was to help himself get reelected, doesn't matter whether the rest of it was in the public interest.
Let's take that seriously,
if he was motivated,
Professor,
even in part by a desire to get reelected,
let's take that
would
seriously,
be impeachable.
because Professor,
that's what I was responding
so
to.
So you say that is the distinction you want to make about the claim you asserted on the Senate floor. Others have reacted to it. We've shown that. My question to you then would be, you are the one invoking the principles of criminal law and arguing that criminal standard should apply. You use the terms beyond a reasonable doubt should apply. Right. That's not typically how Senate impeachments have run in the past. You also say then criminal law guides. But as you know, and I think our viewers know, because we've all been refreshing our law school together through the trial and the coverage, criminal law is all about the mental state. So how can you at once say they should use more criminal law?
Intent.
Yes, intent, your mental intent. So if the intent is to knock out your opponent so that you have an easier path to re-election. That's your intent. The fact that you also may think it is or isn't good for cleaning up a random company in Ukraine doesn't salvage you, does it?
No, let me be very clear. Every presidential candidate tries to knock out his opponent. That's why they have people gathering dirt on their opponent. There's nothing wrong. There's something maybe morally wrong, but nothing legally or impeachably wrong with people who try to gather dirt. The question is it part of a quid pro quo? And that's the question that I was responding to. And the point I was making is if the action itself is legal, the managers are wrong when they say that even if one part of the component of what your motive was to get yourself reelected, that alone cannot be enough to turn something legal into an illegal quid pro quo.
Now,
That's the only point I was making.
Let me
move forward. Repeat again.
No, I don't want to do repetition.
No
I have limited time
to engage in illegal conduct.
Moving to a new topic, because we hear you on that one. With regard to quid pro quo, as you mentioned, what was interesting was Lamar Alexander today, again, making some news. A Republican effectively found that they did prove quid pro quo. You made a statement that I thought was really striking because quid pro quo revolves around the deal, around extorting a bribe, around having a deal, and whether that deal, as you say, is corrupt. Take a listen to something that a lot of people found striking, given that the issue is extorting that bribe, that Senator Alexander, a Republican today, says they did prove that. Here was something you said about criminal-like conduct.
You're misstating exactly.
Professor,
everything.
I will give you time, but I'm going to play.
He didn't say bribe.
I'm going to play you on the Senate
words,
floor.
Not his words.
And I'll play his words as well, sir. Here you were on the Senate floor. Take a look.
The position that I've derived from the history would include, and this is a word that has upset some people, but would include criminal-like conduct akin to treason and bribery.
Akin to bribery. And as for Senator Alexander,
That's right.
You and I both like to work with the record evidence. Let's do it. I'll put back up on the screen for everyone. Senator Alexander says that he thought the Democrats proved Trump froze aid to pressure Ukraine to investigate the Bidens. Aid for pressuring the investigation, which even Bill Barr has said would be not something he'd be involved with because it's not appropriate in the United States. So that is what I'm referring to. And my question to you is, how do you say you can't impeach unless there's that kind of conduct when it appears that's exactly the kind of conduct at issue?
Because they didn't impeach him for that. They impeached him for abuse of power and obstruction of Congress. Had they impeached him for bribery, the issue would be very, very different. Had they impeached him for extortion, the issue would be very different.
So if they use those words, you'd be fine with it?
To impeach him for bribery
you'd be fine
or
with it
to
if they
impeach
used
him
the
for
B word?
extortion. Instead, they impeached him for abuse of power.
Is this a drafting issue then? You'd be fine with it if they just used the B word?
No, it's not a drafting issue because they had Professor Tribe on their side. They had a lot of zealots on their side. If they had the evidence, they would have been obviously smart enough to allege bribery or extortion or any of these other things. They didn't have the evidence. They didn't have the votes on that. So they had to come up with some non-constitutional, vague, open-ended criteria that James Madison would have rejected out of hand. Abuse of power, obstruction of Congress. It's because they didn't have the evidence. And Lamar Alexander didn't say that he found that they committed bribery or extortion. If he had found that, then perhaps he would have said, I'll vote for
I just showed it. He found aid
is that the charges made against him
were not constitutionally permissible. He found aid for investigation, froze aid to pressure Ukraine to investigate the Bidens. That's what he found.
Right. That's not bribery. That's not extortion. And if it were, they would have charged him with it. The point is, if you accuse somebody of dishonesty in an indictment, and then he moves to strike the indictment, that would be granted, even if there were a list of things he did that constituted dishonesty. You have to charge something that's a crime if it's a criminal case, or an impeachable offense if it's an impeachable case.
Right.
Now, they didn't charge impeachable offenses. That's what I was brought in to argue. That's what I argued. If Senator Lamar Alexander accepted that argument, I'd be very pleased. I think he made the independent judgment based on his own research.
You can understand, Professor, obviously I don't want to relitigate the entire abuse of power matter here. Two lawyers, we would never relitigate anything. That's a lawyer joke. But I do want to get you on another matter, which is interesting comments by your co-counsel. Here was White House Deputy Counsel Philbin referring to some of your executive theories as radical. Take a look.
As Professor Dershowitz explained, and as I've explained, and I don't mean in the more radical portion of his explanation of his theory, I mean just in terms of what is high crimes and misdemeanors.
Why do you think your co-counsel in this team feel the need to put some distance between what he calls there on the Senate floor, your radical executive theories, and what you claimed?
Well, first of all, I think he was commenting not about what I said. He heard what I said. He was there, and it was anything but radical. What he was commenting on was how it was misconstrued by the media. But, you know, I come from a left-wing tradition. Calling me radical is not an insult as long as my arguments are correct. And I think my argument was correct. That is, you cannot impeach a president if his motive was partially to get himself elected, if he didn't do anything illegal, and he had a public interest motive as well. That's the Lincoln case. Those are the examples I gave. And that's my argument. As long as you take my argument and present it fairly, what I said, then argue with it. Maybe you're right, maybe I'm wrong, but don't mischaracterize my argument, which is what's been done in many areas.
Well, you'll have to go talk to those many unnamed areas to deal with that. We're not mischaracterizing. You and I, we've been interviewing you before you had this portfolio, during it, and again today. So that's precisely to get your views on the record. The other thing that struck me as a very unusual choice, given these arguments, as you say, was for the president to bring in as your co-counsel someone who did argue that abuse of power is impeachable. Ken Starr not only argued it, he said it was the capstone of his case against President Clinton. He put forward abuse of power, and it made it all the way to the floor of the United States House for a vote, as you know. So it was striking to see both him and Robert Ray there. Now, you've worked, given that your services have been in demand, you've worked with all sorts of legal teams, sure. But I'm curious what you think about how that has played, and I want to also play Robert Ray, who, as you know, like Starr, held that position, because when we spoke to him this week, he also disagreed with the extent of your claims that something that was literally used against Nixon and Clinton would now somehow be off the table forever. Take a look.
Abuse of power, I'm not sure you'd necessarily ever want to exclude that as being potentially impeachable. Professor
Dershowitz has been telling the nation you can't impeach for abuse of power. It seems today that you're acknowledging there's more to it than
well, but it's always more to it in the context of abuse of power. You better be really sure and really clear about that. Otherwise, what you have is a standardless impeachment.
It seemed like at times this obvious tension between. I have to state the question and then you get to answer. You've done interviews before,
sure,
Professor.
Sure.
It seems like this obvious tension between their stated positions then and, as you see, Robert Ray's position this week created some tension with what you were arguing on the Senate floor. Do you think that in any way that weighed down the case or not?
Well, first of all, I was told I could make my arguments independently. I didn't show my presentation to anybody before I delivered it. It was my independent assessment. The president had faith in my judgment. Look, I think abuse of power is relevant if you prove an impeachable offense.
I appreciate you joining us.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.